There have been numerous instances, whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president.
Again, as ATF director, what Congress passes is what we deal with.
And I was sharing with you my knowledge of a program in which ATF has defined this term.
In effect, banning, or at a minimum, severely restricting.
This law's broad immunity means blanket immunity, and that gun manufacturers are the only industry in America.
A new suppressor statute was passed, signed into law, and is being used in conjunction with the ongoing efforts to overturn the NFA and ATS regulations of suppressors, as well as the Texas Suppressor Freedom lawsuit. Bill to remove suppressors from NFA. The American Suppressor Association is pleased to announce the reintroduction of the Hearing Protection Act by Rep. Jeff Duncan and Rep. John Carter. This historic piece of legislation, which was originally introduced by Rep. Matt Salmon in the 114th Congress, will remove suppressors from the purview of the National Firearms Act, replacing the antiquated federal transfer process with an instantaneous NICS background check. The HPA also includes a provision to refund the $200 transfer tax to applicants who purchase a suppressor after October 22, 2015, which was the original date of introduction. The American Suppressor Association believes that citizens should not have to pay a tax to protect their hearing while exercising their Second Amendment rights, said Knox Williams, President and Executive Director of the ASA. We are thrilled for the opportunity to work with Representatives Duncan and Carter, who have reintroduced the Hearing Protection Act in this new Congress. Although we recognize that introducing this bill is the first step in what will be a lengthy process to change federal law, we look forward to working on the Duncan-Carter bill alongside the Congressional Sportsman Foundation and the NRA to advance and ultimately enact this common-sense legislation. Also known as silencers, suppressors are the hearing protection of the 21st century sportsman. Despite common Hollywood-based misconceptions, the laws of physics dictate that no suppressor will ever be able to render gunfire silent. Suppressors are simply mufflers for arms, which function by trapping the expanding gases at the muzzle, allowing them to slowly cool in a controlled environment. On average, suppressors reduce the noise of a gunshot by 20 to 35 decibels, roughly the same sound reduction as earplugs or earmuffs. In addition to hearing protection, suppressors also mitigate noise complaints from those who live near shooting ranges and hunting lands. Unfortunately, suppressors have been federally regulated since the passage of the National Firearms Act of 1934. The NFA regulates the transfer and possession of certain types of arms and devices, including suppressors. Currently, prospective buyers must send in a Form 4 application to the ATF, pay a $200 transfer tax per suppressor, undergo the same background check process that is required to purchase a MASH arm, and wait months for the ATF to process and approve the paperwork. In stark contrast, many countries in Europe place no regulations on their purchase, possession, or use. The Duncan-Carter Hearing Protection Act will fix the flawed federal treatment of suppressors, making it easier for hunters and sportsmen to protect their hearing in the 42 states where private suppressor ownership is currently legal, and the 40 states where hunting with a suppressor is legal. This legislation will remove suppressors from the onerous requirements of the NFA, and instead require purchasers to pass an instant NICS check, the same background check that is used during the sale of long arms. In doing so, law-abiding citizens will remain free to purchase suppressors, while prohibited persons will continue to be barred from purchasing or possessing these accessories. Trump-era bump stock ban overturned by federal appeals court. A Trump administration prohibition on bump stocks, which enable a shooter to rapidly fire multiple rounds from a semi-auto weapon after pushing the trigger once, was overturned by a federal appeals court in New Orleans. The ban was implemented in response to the mass slaying of several dozen people in Las Vegas in 2017 by a killer utilizing arms equipped with bump stocks. Arm rights activists have challenged it in a number of courts. The Fifth U.S. Circuit Court of Appeals rendered the most recent ruling on the issue, which will likely be decided by the Supreme Court 13-3. The verdict won't instantly lift the prohibition, even though it will now go back to the lower court to decide how to proceed. Because the issue in this case was not the Second Amendment, but rather the proper interpretation of federal legislation, it was a little different from other cases. Bump stocks are not illegal MASH weapons under federal law, as stated by those who oppose the ban. The U.S. Bureau of Alcohol, Tobacco, Firearms, and Explosives claims that they do. The Biden administration is presently defending this assertion. The lead majority opinion was written by Judge Jennifer Walker Elrod, who stated that a bump stock is not included in the technical definition of a mash gun, as defined by the Arm Control Act and the National Firearms Act. This conclusion is reached after closely examining the mechanics of a semi-auto arm and plainly reading the statutory language.
and to use it lawfully. That's not a right of government.
There have been numerous instances, whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president.
They just want to regulate guns. They don't. They want to abolish guns.
That this law's broad immunity means blanket immunity, and that gun manufacturers are the only industry in America.
The court decided that bump stocks are not covered by the definition of a mash arm, which is specified in two separate federal statutes. The 6th U.S. Circuit Court of Appeals in Cincinnati, the 10th Circuit in Denver, and the Federal Circuit Court in Washington had all challenged the ban before it was overturned. 3 justices on the 5th Circuit panel affirmed a lower court ruling supporting the ban, made by a federal judge in Texas. Still, the entire court in New Orleans made the decision to reconsider the matter. On September 13, disagreements were heard. Bump stocks are designed to capture the energy of recoil from semi-auto arms. This allows the arm to reset and fire without the shooter having to physically manipulate the trigger again, as stated by the ATF. Court documents state that a shooter must keep the non-shooting hand on the weapon and provide persistent forward pressure, as well as continuous trigger finger pressure. The ATF ruling was opposed by the entire appeals court. They had argued that the weapon does not fit the statutory definition of a mash arm since a bump stock repeatedly pulls the trigger. They point to a paragraph in the law that defines a mash arm as one that discharges continuously with a single function of the trigger. A resounding majority also agreed that Congress should settle legal ambiguities in conformity with the legal ideal of lenity. In a dissenting opinion, Judge Stephen Higginson refuted the assertion that bump stocks are not machine weapons as defined by federal law. He further asserted that the majority had used the lenity concept too liberally. According to Higginson, under the majority's rule, the defendant wins by default in situations where the government is unable to show that a legislation clearly criminalizes the defendant's behavior. Testifying against the restriction on behalf of an arm owner in Texas, Richard Samp voiced his satisfaction with the ruling at the September proceedings, saying he had expected it. Samp claimed to have testified against the law on behalf of an arm owner in Texas. Requests for comments made during the evening were not answered by the Justice Department. The judges who decided against upholding the restriction included Elrod, Priscilla Richmond, Edith Jones, Jerry Smith, Carl Stewart, Leslie Southwick, Katharina Haynes, Don Willett, James Ho, Kyle Duncan, Kurt Engelhardt, and Corey Wilson. Except for Stewart, every member of the appeals court was appointed by the Republican Party. Judge Higginson's dissenting opinion was concurred with by Judges James Dennis and James Graves. Judge Dana Douglas, a recent appointee of Democratic President Joe Biden to the 5th Circuit Court of Appeals, presided over the argument. 5th Circuit overturns ATF's bump stock law. In the Cargill v. Garland case, the 5th Circuit Court of Appeals upheld the legitimacy of the ATF's final rule on bump stocks, overturning the ATF's abuse of power. The ATF recommended that the Supreme Court review the Cargill case in order to support their bump stock regulation. The 5th Circuit reversed the lower court's decision and sent it back to the district court for a decision that would have favored the plaintiffs. This ruling had a big influence on the new regulation, previous ATF overreach regulations, and bump stock legislation. Whether the ATF's final rule on bump stocks should be deferred to Chevron, or if an independent rule called the Lindy Rule should be applied instead, was one of the key questions in this argument. The 5th Circuit's Amang panel determined 13-3 that the ATF had overreached itself in designating bump stocks as mash guns in accordance with the General Motors Act. According to them, the ATF regulation violated the legal tolerance for individual liberty. The technical definition of a mash gun as defined by the GCA and NFA does not contain a bump stock, as can be shown by a cursory study of the relevant statute text and some basic understanding of the workings of a semi-auto weapon. The agency's standard interpretation, according to the court, that the ban on mash guns does not extend to the particular type of bump stock in question, is untrue.
In effect, banning or at a minimum severely restricting
The limited exemptions are negligence, knowingly selling to somebody who's not allowed to have a firearm.
In the event that Congress or the ATF wishes to expand the definition of a mash gun to include items such as bump stocks, they must amend the Act's language. The ATF is powerless to do so on their own. The ATF filed a petition with the Supreme Court to review the Fifth Circuit's decision because they believed it to be at odds with decisions rendered by other circuit courts. The identical interpretive rule has already been challenged and rejected by these other circuits. The ATF goes on to say that after submitting their petitions, circumstances have changed, which has further complicated the legal system. The Hardin decision, a recent ruling by the Sixth Circuit Court of Appeals, has stoked controversy regarding bump stock regulations. Given that some circuit courts allow the purchase or possession of bump stocks and others do not, this ruling highlights the importance of the Supreme Court re-examining the matter. This disparity compromises the consistency of federal law, since decisions made by other courts that have rejected similar arguments have less practical significance. The majority of bump stocks manufactured and sold in the Sixth Circuit, according to the ATF, will likely soon be located in other regions of the country, which makes a unified legal framework even more necessary. The ATF believes that bump stocks pose a substantial risk to law enforcement and the public, even in the absence of compelling evidence. It is even more critical to remedy regulatory discrepancies in light of the perceived threat. In an effort to have the matter heard and granted certiorari, both sides have implored the Supreme Court to reconsider the case. The Sixth Circuit Court of Appeals concluded that the wording used in the Act was ambiguous and chose to follow a standard more akin to the rule of Lindy than the Chevron deference approach. Currently, both parties are requesting a review from the Supreme Court, but they are approaching the matter in different ways. The ATF is opposing any attempt to specifically include the rule of Lindy in the question for this case, arguing that the question they initially submitted to the Supreme Court in their petition will adequately address the issue. The fact that both parties are asking for reconsideration, albeit in different ways, is noteworthy.
That is not a priority.
Okay, here's the problem we have. Here's the problem we have. Okay, you ran for Ohio Attorney General in 2018.
And in those cases, firearms dealers on the southwest border are required to make a multiple sale report.
I believe, to infringe upon good law-abiding Americans' rights. And you're going to turn them into criminals with this regulation, and you seem to have no remorse about it.
Where they were labeling their weapons. Would there be a label on the wall for assault weapon?
The ATF has previously stated that it is against the idea of bringing up the rule of Lindy in particular, outlining its strategy for the impending legal dispute. The reason the Supreme Court is particularly interested in this subject is that it is often called upon by circuit courts to resolve conflicts of law by providing the court with guidance on important legal matters. The Fifth Circuit en banc panel's decision rejecting the bump stock ban would set precedent in the Fifth Circuit and prevent the ATF from enforcing the limitation there if the Supreme Court decides to grant review. The Supreme Court might find it challenging to decline to consider this case, considering the range of opinions and decisions from other circuits. The potential for notable differences in federal law and ATF enforcement underscores the gravity of this issue, indicating that the Supreme Court will probably have to take it up. Suppressor freedom law. The NFA and ATF prohibitions on suppressors manufactured in Texas were to be repealed through the Texas suppressor freedom litigation. Paxton versus Dettelbox, as the case was once known, was decided on cross motions for summary judgment. The judge's decision seems like a softball because standing is invoked as an excuse to sidestep discussing contentious matters. The plaintiff's lack of a tangible injury to satisfy the standing requirement was decided by the court. Furthermore, the court ruled that Texas could not act as a stand-in for its citizens to sue the government over the NFA's application to suppressors manufactured in Texas. Texas House Bill 957, which sought to exempt all suppressors manufactured and stored in the state from federal regulation, gave rise to the case. This statute was based on the argument that since these products are only manufactured and marketed in Texas, they do not qualify as interstate commerce and are therefore exempt from federal regulation by the ATF. Texas filed the complaint against the government together with individual plaintiffs, and as a result, this matter was brought before a federal court on cross motions for summary judgment. The court was faced with three options after arguments last month. It could allow the plaintiffs' move for summary judgment, rule in favor of Texas and the individual plaintiffs, or grant the government's request for summary judgment in favor of the ATF. Ultimately, the court decided that the government had the right to win the case, finding that the plaintiffs lacked legal standing. The judge made it clear that to be illegal in order to have standing in the action. Additionally, they might be able to boost their reputation by proving that they have been directly threatened by the ATF about the manufacture of homemade suppressors. A party must establish a reasonable danger that they will sustain a direct injury as a result of the legislation's execution in order to successfully challenge a criminal statute before it is put into effect.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
As suppressors illegal nationwide, just as they are in New Jersey.
But according to the judge, a plaintiff would have to engage in actions deemed unlawful before they could legally challenge the ATF. This would be akin to the plaintiff falling on their own sword for the benefit of the Second Amendment movement as a whole. In this instance, the judge decided that just claiming that the statute in question infringes upon the rights in question and violates the Second Amendment does not relieve the burden of showing standing. It doesn't matter if an application is eventually approved or denied, because the individual plaintiffs haven't attempted to file an application to produce and register a silencer. It is possible for the plaintiff to suffer harm as a result in any scenario. In the event that an application is unintentionally rejected, the government will have injured the applicant by depriving them of a silencer. On the other hand, since the plaintiff will have to go through the procedure and pay the tax, even if the application is approved, they can still sustain losses. According to the judge, the plaintiff's wish to show that they were in violation of these laws by producing a silencer does not establish that the method they are trying to challenge has caused them any real injury. To put it simply, people must subject themselves to the exact process that they want to scrutinize. The question of Texas's legal standing to file this complaint is also addressed by the court. In an attempt to prevent the National Firearms Act from applying to suppressors built in Texas, the judge determined that the state of Texas could not file a lawsuit against the federal government on behalf of its residents. Texas's state legislation exempting silencers from they intend to create the first suppressor made in Texas, or who could be threatened by the government or the ATF with regard to homemade suppressors. State-by-state suppressor deregulation. A Mississippi statute, largely influenced by the Texas suppressor freedom lawsuit and ongoing efforts in Texas's Fifth Circuit to repeal Maiden's NFA and ATS regulations, has been enacted. This law, known as HB 912, collaborates with the Texas suppressor freedom lawsuit, aiming to create a state-by-state movement to deregulate suppressors exclusively manufactured and kept within certain states. The Mississippi governor signed and sent HB 912 earlier this year, and its existence came to attention when some viewers mentioned it in the Texas suppressor freedom case. The Mississippi law seeks to ensure that arms suppressors produced and retained in the state are exempt from federal laws and regulations governing such devices. Additionally, it prohibits state and local government representatives from enforcing federal regulations on suppressors made in Mississippi. The primary objective of the Mississippi law mirrors what Texas achieved with its suppressor freedom law.
Makers of the silencers are the ones pushing state lawmakers to lift the ban, and they have found at least one supporter.
The two, action people shooting at each other with suppressor, nobody else knows what's going on. That's completely unrealistic.
However, its implementation is contingent on the outcome of the ongoing Texas suppressor freedom lawsuit, specifically Paxton versus Dee. The law includes a provision withholding state funding from any government agency in Mississippi that adopts a rule or policy aiding in the enforcement of federal suppressor laws. While the Mississippi law has been passed and signed, it specifies that it will not take effect until the resolution of the Texas lawsuit mentioned within the legislation. This Texas lawsuit originates from House Bill 957, passed in 2021, aiming to exempt from federal regulation all suppressors made and retained in Texas. The argument revolves around Texas and a few individual litigants suing the ATF after facing oppression from others in the state. The case reached the Northern District of Texas Federal District Court, where a judge, upon cross motions for summary judgment, ruled in favor of the government and the ATF. The district court judge emphasized the contested element of standing, stating that the plaintiffs had not suffered an injury in fact, leading to the conclusion that they lacked standing. Consequently, the court ruled in favor of the government based on this rationale. Legal standing and challenges. The judge in the Texas case asserted that individual plaintiffs were correct in noting the government's history of prosecuting illegal possession of unregistered silencers. However, the judge emphasized that these plaintiffs failed to provide evidence that they possessed any illegal silencers or engaged in prohibited conduct. Furthermore, the plaintiffs did not demonstrate that they faced a credible threat of prosecution, and the judge stated that doctrines of criminal law prohibit convicting individuals based solely on thoughts, desires, or motives. Thus, the judge deemed the individual plaintiff's fear of prosecution as imaginary or speculative, lacking the substantial basis required for Article III standing. In essence, the judge articulated that individual plaintiffs in Texas would need to allege possession of an illegal silencer or engagement in prohibited conduct that the ATF deems illegal to establish standing. The court also suggested that plaintiffs could demonstrate standing by showing direct threats from the ATF or by attempting to register one of these Texas-made suppressors with the ATF. The judge maintained that intent alone was insufficient. There must be evidence of actual illegal activity for standing to sue the ATF. In the Texas case relied upon by Mississippi, the lower court judge ruled that the state of Texas lacked standing to sue the ATF, arguing that the state could not represent its citizens in such a lawsuit.
Law enforcement later surmised he was shot by someone using a silencer.
Whiteside County Sheriff, to discuss about the new bill, and he says that the bill is unconstitutional.
Consequently, the judge granted the government's motion for summary judgment, dismissing the case in its entirety. Subsequently, Texas has appealed the ruling, requesting the Fifth Circuit Court of Appeals to examine and overturn the lower court's decision regarding standing. Texas argued that the case's constitutional significance warranted oral arguments, raising questions about whether Texans have the right to challenge statutory requirements before obtaining permission and paying the tax, and whether Texas can immediately defend its quasi-sovereign interests in the health and safety of its citizens. It's worth noting that some individuals have expressed indifference, stating that this Texas suppressor freedom case may not seem relevant to them. National implications of the Texas suppressor freedom case. Some individuals believe that the Texas suppressor freedom case exclusively pertains to Texas, but this is not accurate. The case is currently under review by the Pro-Second Amendment First Circuit Court of Appeals. The decisions emanating from the First Circuit, including lower courts, have had widespread implications nationwide. It's crucial to recognize that more states than just Texas fall under the jurisdiction of the First Circuit. Additionally, states like Mississippi are proactively leveraging the Texas law and lawsuit, seeking to emulate similar deregulation for suppressors on a state-by-state basis. This case is expected to reach the Supreme Court eventually, or at the very least, request Supreme Court review. Any decision by the First Circuit or the Supreme Court will likely have broad applications for numerous Second Amendment cases and may prompt other states, potentially even your own, to pass laws similar to those in Texas and Mississippi, facilitating state-level deregulation of suppressors. In Mississippi, HB 912 stipulates that the law will take effect and be enforced after the U.S. Supreme Court rules in favor of the Texas Attorney General and the state of Texas regarding the passage and implementation of Texas House Bill 957. The specific case mentioned is Paxton v. D. This underscores the substantial ramifications of the Texas suppressor freedom case for potential state-by-state deregulation. It's essential to bear in mind that despite these developments, the ATF currently treats suppressors as regulated items subjected to the restrictions of the National Firearms Act and the Gun Control Act. The ATF will continue to pursue individuals who engage in this conduct without proper filing of a Form 1 and adherence to the correct procedures. For those in Mississippi, it's crucial to note that the state law, as outlined in HB 912, remains inactive until the resolution of the Paxton case. Therefore, vigilance and compliance with existing regulations are still necessary. The hope is that the Fifth Circuit delivers another victory for Second Amendment advocates, possibly leading to Supreme Court review and further shaping the legal landscape for these cases. That's all for this video, folks. See you next time.